Oh, the ranking member.
Mr. Chairman, thank you very kindly. You can stay in a business that is inherently dangerous if you want to. The chairman's right about that, but you've got to follow the law when you do it. Now, as I understand it, Dr. Michaels, and please clarify this for me, because again, we're not a jury. It's starting to sound like people are making closing arguments before a jury here. We just want to make sure the law is being properly enforced, okay? Here's what I understand is going on. Ms. Shult testifies, and to my mind, perfectly honestly, that they've not had no cases from the fabricators that they work with within their own business of silicosis. They've not been sued by their own fabricators, but they weren't sued by fabricators. They weren't sued as a fabricator. They were sued rather as a seller and a manufacturer, because there's a whole different apparatus of law that applies to manufacturing something, putting it into the stream of commerce, and selling it to people. Now, as I understand it, they were held liable in cases because they did not comply with the duty of care, and there was a failure to warn. In other words, they were selling to people without warning of the inherently dangerous properties of their product. It's like your example of the cigarettes. Cigarettes are perfectly safe until someone smokes them. Well, if you're the manufacturer of cigarettes, you know people are going to smoke them, and of course, Cambria understands how their product is going to be used and that it is going to be part of a construction process. But they have not engaged in the proper reasonable failure to warn. They don't like the consequences, which is that they've been sued for it and they've been held liable in court. I don't know what it is we can do about that. If you want to change the laws of product liability, if you want to change the laws of failure to warn, go ahead and change them, change tort law, but don't come to the Congress and expect us to essentially destroy the tort laws of 50 states in the country by giving immunity to one business because it happens to be owned by a friend of Donald Trump's who's a billionaire Republican donor. Come on, this is like ridiculous what we're being asked to do, which is why we're getting letters from the American Lung Association telling people not to support this. The AFL-CIO has sent out a message about this. Now, to be clear, Ms. Shult, let me just give you a chance to answer what I just said. You talked about Cambria University, where you educate on the proper methodologies for using your product. Is that right? Is that what that does?
It's broader than that. It's really a knowledge and learning exchange center where stone fabricators and installers from around the country can come together and share best practices. Okay. And of course,
so are your buyers required to go through that process?
No, but okay. we
so
do
you're
provide
selling you are selling to the bad apples you're denouncing today.
No.
Basically, no, you're not.
Well, I can tell you.
Yeah.
There are 400 cases, so I can't speak to all of them. But
yes.
For the 2 cases that went to trial, including the one where Cambria was found liable,
yes.
and has a $10 million judgment against it,
yes.
even though the employer was responsible for 70% on the verdict form.
And you were found responsible 10%, is that right?
We never contracted with that employer to sell slabs to him. Same thing with the second lawsuit. Okay. We're facing lawsuits
you were the upstream supplier that got down to them. But in any event, that's what tort law is all about. We're not a jury. Somebody worked that out and said you were 10% liable in that case, and that's what you ended up paying. So, but I don't understand exactly what your complaint is. I mean, nobody wants to be sued in America, but the alternative is that we have lots of people who are wronged all over the country who are injured and damaged. I mean,
Mr. Raskin, may I explain, please?
Please.
Thank you. So the intent of HR 5437 is to address the situation where third-party misuse is the cause of injury. So is
it any cause, not the complete cause, but... Well, there's the problem right there. In other words, you're basically saying you want them to take 100% of the rap for it, and you don't want to take any responsibility as a seller of it, but that's not what the law is in California.
That's absolutely incorrect, Mr. Raskin. Okay. If I may finish, please. Thank you. Cambria, according to HASCOM, identifies the potential hazard of respirable crystalline silica when stones are unsafely cut in violation of OSHA's requirements. It's on our safety data sheet.
Forgive me, I only have 9 seconds left. Here's what I got to correct in what you're saying. you can't just pin it on the regulators, okay? That's like saying if somebody drives and smashes into your car, but they weren't violating the speed limit, they're not guilty. Just because you are within the state's regulatory system doesn't mean you have not behaved unreasonably with respect to the rights of another person. That's why we have the tort law system. Otherwise, everything would just be criminal law and regulation. So it's not enough to say, well, we've got OSHA out there, OSHA will take care of it.
I apologize. I don't follow all of the example of the automobiles, but with respect to cars, we don't sue car manufacturers when somebody speeds or drives drunk. Car manufacturers still get to exist, even though people criminally
absolutely,
use
but
their products.
if the car is created with certain product deficiencies in it, and there are liabilities in the way it's been constructed, the auto manufacturer and the sellers are all responsible along the way. That's exactly the situation you're in.
I disagree, Mr. Raskin. The language of the HR 5437 that's proposed is limited so that we're only seeking relief from these lawsuits that are being caused by the illegal misuse, oftentimes which might be criminal.
No, you're looking for categorical absolute immunity in all of these cases.
That's incorrect.
So when would you be liable?
If there was a genuine defect in the product that made it so that in normal use it was
But on your
causing the
definition,
illness,
there's
that would
no
be different.
defect in the product, right? So how could you ever be held liable? You're basically saying you're not responsible for educating anyone downstream.
That's not at all true. We do educate downstream, and we take responsibility for what we need to do. This is a copy
Well, then a jury found you had not
label.
done it. A jury found you didn't live up to it,
No,
but then
that's incorrect. Mr. Raskin, I don't believe failure to warn was even a claim, or was even went to the jury in that trial. I'll double check and confirm that in my written testimony. But no, there was no failure to warn because people testified that even if they saw the label, they wouldn't do something differently. We know of situations where there are sick workers who have been diagnosed with silicosis, who have been to the doctor, who have been told they have silicosis, who are being deposed and literally leave the deposition so they can go back to work where they are overexposed to dangerous silica dust. This problem is much larger than
all right.
Whether or
you
not
described it as a couple of bad apples.
If the gentleman,
sell.
I've been very, if the gentleman will has something new, I'll allow it. But let's be brief.
Okay, I'll close with this question then, because you've described it as basically a handful of bad apples. Although Dr. Michaels said that silicosis is showing up, I think, in 50% of the cases, so that he describes it as pervasive in the industry, and that's a question of fact a jury would have to figure out. But if you know who these bad apples are, if they are the illegal, immigrant sweatshops that Mr. McClintock described so vividly, why do you sell to them? Why don't you just stop selling to those people and making sure it doesn't get down to them?
Yes.
Ms. Shult, you can answer that.
Thank you very much. We have no interest in selling to unsafe shops. There is no benefit to us. The people who are making money off of the backs of these workers are the fab shop owners themselves. They are cutting corners by dry cutting. It costs more money to do this safely and to use water properly and to use the right equipment and to follow OSHA's laws. Those are the bad actors that are making money off of this. Cambria and other manufacturers and other members of the industry have been trying to work with the Cal-OSHA board to try to get some sort of licensing or certification program in place so that we can only sell to certified, licensed, acceptable fabricators. We want that legislation. It was part of SB 20, which recently passed in California, but unfortunately that certification requirement was pulled from the bill at the last minute. We're doing everything we can to work with Cal-OSHA and other regulators in California to try to promote worker safety, to try to educate people in the industry about this problem. And the very reason that we're really here today is to help raise awareness to the problem and to seek relief from this onslaught of lawsuits that threaten our good American manufacturing jobs and jobs throughout our entire industry.
Mr. Chairman, thank you for your patience, and it does sound like it's overwhelmingly a California problem. I hope you guys in California can work it out, and I assume that you can. Thanks.